First of all, thank you very much for attending. The Law Commission is a consultative body, so we can only complete our projects if consultees engage with us. So we're very grateful for you taking time out of your busy days to come and chat to us about chancel repair. It is a niche subject, but it can be interesting, and it can be of really serious relevance in rare cases. So the plan for the evening is, first, I'm going to hand over briefly to Professor Lisa Webley, who is the new Commissioner for Property, Family and Trusts at the Commission, to say hello to everybody. Unfortunately, she can't stay for the whole event, but will be here for the beginning. Then I have a presentation on chancel repair liability and what our project's about, which I hope will be of interest. If anybody has questions or doesn't understand a point as I'm going through it, please feel free to raise your hands. I can always pause and we can discuss an issue if it's not clear. If you've got a general point that will wait till the end, I'm going to try not to speak for longer than 40 minutes, so we should have plenty of time to discuss any particular questions or issues you have at the end. And then finally, we'll have a time at the end for questions. So if I start by handing over to Lisa, and then she'll hand back to me.
Thank you very much. Thank you very much, Chris. And lovely to meet you all, albeit via this method. And thank you for being willing to give up your time this evening and to provide your expertise as well to the Law Commission in relation to chancel repair. Without you, it's really difficult for us to be able to come up with recommendations which are going to be not just legitimate, but also useful. So as Chris has said, I'm Lisa Webley. I'm the new Law Commissioner for Property, Family and Trust Law. Many of you will know my predecessor very well, Professor Nick Hopkins, and I'm very grateful to him for having given me a briefing on all that's gone before in relation to chancel repair, but also I'm very grateful to Chris and the team in relation to the project as well. Now, I'm very conscious I'm not going to be able to fill Nick's shoes, either literally or figuratively, in relation to chancel repair, but I'm reassured, not just because the team is extremely expert in this area, but also from the expertise that I see that many of you are actually bringing to this. So thank you ever so much for being willing to be at this event. I hope I have an opportunity to meet you properly in person before too long. And without more ado, I just want to hand back over to Chris, who's going to do an excellent job of chairing the event this evening, who's going to take us through the project itself and then take questions and also your thoughts on what it is that we need to be considering as we work our way through. So lovely meeting you, and thanks ever so much for your time and your expertise. I'm very grateful.
Okay, hopefully that won't create a huge echo. I'm going to share my screen to throw up a PowerPoint. My aim is to take you through some of the issues we discuss in the consultation paper and introduce our project to you. I'll work on the basis that you haven't read the paper. The paper is, I mean, it's not our longest, but it is technically difficult, particularly the opening chapters. And hopefully, if you have read it, I'll be able to add something to it. And if you haven't, I'll be able to give you a flavour of what it's about, to make it easier for you to engage with us if you want to. As I said, if you have questions that need to be answered as I'm going through, feel free to stick up a hand and I'll pause and address them. But starting off, we've published a consultation paper on the 15th of July. The consultation window is still open. It's not due to close until the 15th of November. So there is time to respond to the questions in the paper if you wish to. All the details of how to do that can be found on our website. The project is an examination of land registration and chancel repair liability. So it is not an entirely independent examination of chancel repair liability by itself. We're looking at it in the context of land registration. So first, by way of background, this is a slightly difficult consultation because we want information from ordinary landowners, homeowners, people who own commercial sites who might be affected by chancel repair liability. We want information from anybody who's bound by the liability. We've been keen to engage with the Church of England, the Church in Wales, with parochial church councils, with solicitors and conveyancers who have to advise on transfers of land, insurers who provide chancel repair liability insurance, and those who provide searches, academics, ecclesiastical lawyers, property lawyers, historians. And that makes both the paper and this presentation a little bit tricky because some bits are very straightforward and some bits are very technically difficult. And what we try and do in the paper is isolate the technically difficult bits and then give a summary of what the upshot is, and then ask general questions that anyone can engage with. But starting from absolute fundamentals, the first question, if you know nothing about chancel repair liability, is probably, what's a chancel? A chancel is the eastern end of a church, the end that contains an altar. It'll also contain often the choir pews. Frequently there's a step between the chancel and the main body of the church, partially because pre-Reformation, when churches were all Roman Catholic, there used to be a rood screen, a screen that was put up that blocked vision of the altar. A chancel repair liability, in a nutshell, is an obligation to keep the chancel in good and substantial repair, which includes rebuilding it if it falls down. The person who's liable isn't required to modernize the building, make additions, decorate it, but they are responsible for its fabric and its structure. And importantly, all the relevant churches are more than 500 years old. So we're talking about buildings that are almost invariably stone and contain oak, tile, lead. These things are very expensive. So in theory, chancel repair liability can be very extensive. The only case that's arisen in the last couple of decades was the wall banks against Aston Cantlow Parochial Church Council. But in that case, the final repair bill came to £190,000 plus VAT, so more than £200,000, and that's not including any legal costs. That's in 2007, so it's 15 years ago. Accounting for inflation, the amount of money that somebody might be liable for could be considerable. But I should say, chancel repair liability is an obligation to repair the church, but we're not interested in just any kind of obligation. Because after all, if a church hires a builder to come and redo the roof, the builder, once they've signed a contract and taken payments, under an obligation to repair the chancel. But that's not the kind of obligation we're looking at in this project. We are looking specifically at an obligation that used to only apply to parish priests. Historically, in England and Wales, the parish priest was responsible for repairing the chancel, and the parishioners who contributed via church rates were responsible for repairing the main body of the church. Now, those liabilities don't exist anymore. Parochial church councils have now taken over the responsibility for repairing the entire church. But various events happened in the 16th century connected to the dissolution of the monasteries. And as a result of that, some of the liability that used to fall on parish priests transferred to some other people. some bodies like the Church Commissioners, some dioceses, some educational institutions, Christ College, Cambridge, Eton College, and importantly, some landowners. And our project is only considering the liability of landowners. So it is only considering someone who's become liable to repair the chancel because they bought land. And it arises specifically from previous work we did on land registration. Because during our project on land registration, some consultees, particularly the Law Society, wrote in and said that there were some concerns about how the act which governs land registration, the Land Registration Act 2002, how that act applies to chancel repair liability. In fact, I could say that what we're specifically interested in is purchasers of registered land. We want to ensure that somebody who buys registered land can look at the register of title, can see whether or not there's a chancel repair liability on the register, can be certain that if there is not one recorded there, they will not be bound, and can buy land on that basis or make an informed decision. So what I'm going to do is I'm going to go through some relevant bits of the Land Registration Act quickly. These will be familiar to some of you, but it's worth looking at some of the legislation in a bit of detail. And then I'm going to talk a bit more about the nature of chancel repair liability, including its history, which I hopefully will be of general issue, certainly to anyone who's a law geek like me. But the historical events are inherently quite interesting. So starting with the Land Registration Act, we're looking at several aspects of the Act, but the key provision that we're looking at is Section 29, and this is the provision that deals with. Well, I've thrown it up on the screen. Let me highlight some bits of it. So, Section 39 starts with if a registrable disposition of a registered estate. So it is dealing with registered estates, not unregistered land, and it's dealing with registrable dispositions. The only thing that's important to know is that will include transfers of freeholds. So a transfer of a freehold, a registered freehold, that's going to be potentially caught by Section 29. Secondly, it's dealing with registrable dispositions for valuable consideration. So this is about sales of land. And the effect of a sale of registered land is that something gets postponed. And by postponed, it means it's whatever it is that the section's acting on isn't binding on the person who's bought the land. And what sort of things does the section apply to? It applies to any interest affecting the estate. So if there is an interest affecting the estate, the default position under Section 29 is that it is postponed when the estate is sold, meaning it's not binding on the purchaser, unless its priority is protected. So if I skip ahead quickly, there's two ways usually in which an interest or a burden affecting land can be protected under the Land Registration Act. It might be what's called an overriding interest. That simply means it's been listed at the end of the Act as an overriding interest in Schedule 3, and it doesn't need to be registered in order to bind someone who binds the land. It can bind them automatically. Or an interest is protected if you enter a notice, meaning the interest is visible, everyone knows it exists because there's a notice in the register. Very briefly, overriding interests have existed since the beginning of land registration legislation. They generally are, at least under the 2002 Act, the policy was that an overriding interest should usually be an interest that's short-lived or one that would be obvious on an inspection of the land. So the key example of an overriding interest is something like a short lease, because if you buy a piece of land, you're supposed to go and inspect it. And when you inspect it, you'll find there's a leaseholder living there, and you should ask some questions. And if you don't, well, then you only have yourself to blame, or at least that is the policy underlying the Act. Very briefly, notice that a notice is defined in section 32. It's an entry in the register in respect of the burden of an interest affecting a registered estate. That phrase, interest affecting a registered estate, is the same one that was used in section 29, and it's a phrase repeated frequently throughout the Land Registration Act. And it's a key phrase that we're going to come back to. But a notice is something that records an interest affecting an estate. Now, turning to chancel repair liability, originally, well, since 1897, the Land Transfer Act, chancel repair liability has been listed as an overriding interest, as something that will bind automatically without needing to be registered. Why? We don't know, because a chancel repair liability isn't something that's easy to discover by inspecting the land. It's not something that's short-lived. It's not something that's informal or unreasonable for someone to register. It may be very onerous. But until the 2002 Act, and in fact, for the first 10 years that the 2002 Act was in force, chancel repair liability was listed as an overriding interest. But from the 13th of October 2013, it dropped off the list, and it was assumed that since chancel repair liability isn't overriding, that means you must need to register a notice of it in order to bind a purchaser of land. So what's the problem? Well, the first sign that there might be a problem is that purchasers of land still routinely pay for chancel repair liability insurance. And they still fairly frequently pay for searches of, it's called the record of ascertainments, but the parish records of who might be subject to chancel repair liability. And it appears that purchasers do this frequently, regardless of whether there's any liability noted on the title. And we have a suspicion that the reason that this is happening still is because of uncertainties about the nature of chancel repair liability. And very briefly, there was a memo written pre-2010, in about 2009, by the Law Society that said chancel repair liability might not be caught, might be a weird kind of obligation that's not caught by the Land Registration Act. That memo went to Land Registry, who looked at it and thought, there might be something in this. And Land Registry noted the uncertainty in their guidance. So the issue at the moment is that if you're a solicitor or a conveyancer and you're advising a client about whether or not they should take out chancel repair liability insurance, you might look at Land Registry's guidance and see, oh, there's some uncertainties about the nature of this. So good practice, if the insurance policy is very cheap, is perhaps to say, well, you might as well take it out. But what we were particularly looking at in our paper is whether these uncertainties about the nature of chancel repair liability have anything in them. Autobiographically, I should say that when I started this project, my initial view was there was no problem here. Obviously, chancel repair liability is an interest in land. Obviously, the Land Registration Act works fine. I couldn't see where the issue was. So the question is Land Registry, is chancel repair liability subject to the Land Registration Act? And it looks like it is if it is an interest affecting an estate, because that's what the Act is making provision about. And it defines interests affecting an estate. In section 132, it says an interest affecting an estate is an adverse right affecting title to the estate. So I guess the question for us was, is chancel repair liability an adverse right that affects title to land? And that's what we set out to look at in the chancel repair liability consultation paper, particularly in the technical chapters, chapters 2 to 5. So what I was hoping to do, just check how I'm doing for time. Oh, no, it's fine. Was run a little bit through the history of chancel repair liability and explain to you why we think there's an uncertainty about whether or not it's caught by the Act. I should say our consultation paper doesn't suggest that it definitely isn't or that it definitely is. We say there are reasonably good arguments that Chancel repair liability is not caught by the Act. There is a genuine doubt here. And the reason for that is because of our investigation of the history of the liability. So I'm going to try and explain to you what it is we found, what the upshot of our research was, and why we think there's a possible problem with the Act and why it might need clarifying. If you want to look at these issues in more detail, they are chapters 2 to 4 of the consultation paper for the history of the liability. And then chapter 5, we talk about how the Land Registration Act works and what kind of rights it applies to and how it might apply to chancel repair liability. And then part 2 of the consultation paper talks about possible reforms and asks general questions about the impact of the liability. So let's go back in history, back beyond the 16th century. Chancel repair liability, we know quite a lot about how it originally existed, what it originally was, because it was originally an obligation on parish priests. And parish priests, when they were appointed, undertook a range of duties. They had obligations to provide support for the poor of the parish. They had obligations to provide divine service or cure of souls. So they would need to say the Eucharist. They would need to provide burials and baptisms, and they had an obligation to repair the chancel. And in order to support them, they were provided with a range of property and other beneficial rights. So the priest typically would be given a house, often known as the parsonage or the rectory house, and they were given the right to collect tithes from members of the parish. Tithes were a form of ecclesiastical tax, requiring anybody who lived in the parish to give a tenth of the produce of their land. The word comes from the word for tenth, the Latin for tenth. Sorry, it comes from the Old English word for tenth, not the Latin. But in addition to that, they were often given some land that they could let or farm, called glebe land, and they had various rights, such as the best seat in the chancel. They were vested with the freehold of the church and the freehold of the churchyard, and they kept these for as long as they were the priest. It was like the default was it was a life interest. So when they died, it would revert to the church and be given to the next priest. But it would also end if they were dismissed or promoted or resigned. Now, these duties included the duty to repair the chancel, but the duty to repair the chancel was just an aspect of their role, their religious office. It was no different from the duty to provide support for the poor of the parish. And this living, well, you could use the word office, you could use the word living, effectively the job or the role with all the supporting rights and obligations. This living was known as the rectory. So the word the rectory is ambiguous. It can refer to the office with its property, or it can refer to the house. So the next step in our story is about how rectors or parish priests came to be appointed. Now, parishes were, in many cases, not founded by church funds. Some were. In many cases, they were founded by the local lord of the manor, who constructed the church, might also have a private chapel connected to it, and endowed the rectory. So gave the glebe land, created the parsonage house, gave it as part of the rectory. And as a consequence of having founded the rectory, the Lord was given the right to appoint the rector. The rector would have to be canonically qualified. The bishop could refuse their appointment if they weren't. But assuming they were qualified, it was entirely up to the Lord of the Manor who became the rector. And that right was known as an advowson. And the difficulty arose because advowsons became recognised as a bit of private property, a right that could be sold or traded. And so people bought and sold them. and whoever had the advowson was known as the patron of the parish. A brief aside, if you're ever interested in historic land law, it's always worth having a look at the novels of Jane Austen, because most of the issues that you'll come across appear in the novels somewhere. That includes advowsons. So if you're familiar with Pride and Prejudice, we've got the awful character of Mr. Collins. He is in the pocket of Lady Catherine de Bourgh because she is the patron of the rectory of Hunsford, and she appointed him as rector, so gave him his living of whatever, £500 a year, whatever it was. Sense and Sensibility, Edward Ferrars, the well, he's not the hero, but the main love interest of the story. He's disinherited, but fortunately he's given the rectory of Delaford at the end by Colonel Brandon, who is the patron of the parish and has the advowson. Now, difficulties arose particularly between the 13th and 15th centuries because monasteries and other religious houses started to buy up advowsons. And having bought the advowsons, they would either appoint themselves as a corporation or the abbot or the prior or one of their officials as the rector, but not as an individual, as an office. So the abbot and all the abbot's successors became the rector, as a corporation sole would be the technical legal term. This process was known as the appropriation of rectories, and it could happen because monasteries and abbots and priors and other religious officials were canonically qualified, and the advowson allows you to appoint someone provided they're sufficiently religiously qualified. So the monastery then is the rector and enjoys all the income from the rectory. And a practice arose where monasteries would deputize the actual administration to the parish to a substitute, known as a vicar, from the Latin vicarius for substitute. So over the centuries, a lot of laws were passed to control this practice, requiring preventing vicars from being dismissed at will by the rector, requiring the vicarage to be properly endowed so that there was support for the vicar. And a practice arose where the monastery tended to take the income from some of the tithes, known as the great tithes. Those tended to be those were corn, hay, and wood. They were originally the most valuable tithes, but that didn't last for long. And the vicar was given the right to collect the lesser tithes, which included the fruits of industry, which became quite valuable. But still, the idea was the monastery would effectively cream off the income from this religious job, and would delegate the actual performance of it to someone who was only given a portion of the income. It would be like someone taking my job, taking some of my income and just keeping it and sitting at home, and hiring someone for 2/3 of the price to come in and do the job in their place. It was, well, it happened for various reasons. There were various levels of abuse. In many cases, it was a financial wheeze. So I can picture this for you quickly if you look at the slide. So we have a parish priest. They have the office of rectory. It comes with rights and property. It comes with obligations. And they've been appointed by the lord of the manor, who has got the advowson. But something has happened. The monastery has taken the advowson, so the monastery can appoint itself. And they will then take the rights and properties and the obligation, but they can't do everything, because the monastery as a corporation can't provide divine service, which is crossed out. They're probably not making use of the parsonage house either. So the monastery would endow a vicarage, which would give them the advowson of the vicarage, the right to appoint the vicar, and the vicarage would take on some of the rights and obligations. By the way, Support for the Poor's got question marks. It's not clear to what extent rectors retained obligations to support the poor, so whether the monastery took on direct obligations to support the poor. It looks like they did, where there were particular customs to provide support. But importantly, the obligation to repair the chancel would fall on the monastery, the one who had the rectory. We found, incidentally, that it could be shared with the vicarage by express agreement, but as part of the appropriation of the rectory, the monastery, because it was filling the office of rector, had the obligations of rector, so had to repair the chancel. The next step in history comes with Henry VIII. So 1534, the Act of Supremacy is passed. The Church of England splits from the Roman Catholic Church. The king becomes the head of the church. Very, very soon afterwards, Parliament begins a programme of dissolving religious houses and monasteries, partially because there is a background of negative public sentiment about the misuse of church funds by monasteries. So 1535, dissolution of the lesser monasteries, 1539, dissolution of the greater monasteries. Then they continue with the dissolution of the colleges in 1545. Then Edward VI takes it over with the dissolution of the chanceries in 1547. But in all of these cases, the acts all do the same thing. First of all, they dissolve the religious houses in the same way that you dissolve a company. It ceases to exist. So by itself, what that would have done is meant that there was no longer a monastery, so they no longer have the rectory. Whoever had the advowson would then be able to appoint a new rector. So that would have been the default position of just dissolving all the monasteries. But the acts don't just do that. They passed any property that belonged to the monasteries to the crown. Now, by itself, that wouldn't have made a huge difference. It might have taken some property out of rectories, possibly not. But they also authorized the crown to take the rectories themselves, the offices, passed from the monasteries to the crown. And the acts were interpreted very early on to authorize the crown to transfer those rectories to whoever they wanted. And that included some religious bodies like dioceses, but it also included lay persons, people who weren't members of the clergy, principally members of the gentry. So there was an absolutely colossal transfer of wealth. It looks to have been about a third of England's GDP. So a staggering transfer of wealth went from the church to the crown to the gentry. And it was done mostly not by the actual land or other rights transferring, but by the offices themselves, the role of rector going from the monastery to the crown to the gentry. And in chapter 3 of our consultation paper, we look at this in detail, but it looks as if what happened is that members of the gentry, sort of lay people who weren't members of the clergy, were given religious offices. They couldn't perform them because they were not qualified to say divine service, unless they happened to be, in which case they could. But everything that went with the rectory that they could take, and every obligation that they could discharge, and every right that they could meaningfully exercise, went to them with these offices. So if all you know of chancel repair liability is some recent case law, for example, you've read the House of Lords decision in Aston Cantwell and Walbank from 2002, or you've read some of the mid-20th century cases, it can look as if what happened was that there was some property that belonged to the church, it went to the crown, it went to lay people. Because the courts thought it's very unfair to take this property without taking some burdens with it, they applied a bespoke obligation to the property in the hands of lay people, requiring them still to repair the chancel. Our analysis in chapter 3 indicates that that isn't what happened. What happened was the whole office, the whole role, went to lay people, and the lay people became lay rectors. And it looks as if they didn't just take on the obligation of chancel repair liability, but they got the right to the chief seat and the chancel. They got the freehold of the church and the churchyard and the ability to bring claims in trespass if someone encroached upon it. They got the advowson of the vicarage. So if there was a vicar, they got the right to appoint the vicar. They got the right to minister to the parish if they happened to be canonically qualified. There was one case where that occurred that went all the way up to the equivalent of the House of Lords. They got the presumptive right to take tithes from the parish unless someone could show that somebody else had been given that right. So everything that went with the rectory seems to have gone to the lay rectors in the 16th century. And our analysis indicates that what happened, the only differences were that because they couldn't necessarily minister to the parish, they became required to appoint a curate or a vicar to do it in their place. And insofar as any element of church law prevented them from transferring their property to someone else, that got disapplied. So, for example, a parish priest could be dismissed by the bishop, but by the time rectories have gone into lay hands, that power of the bishop is gone. They can't just dismiss a lay rector because lay rectors are entitled under the Acts of Dissolution to pass the property on to their heirs and assigns freely. And another set of cases came up about whether the bishop could take some property away from lay rectors and endow a vicarage, and the court said no. So the property is out of the control of the church. So those elements, the law of church law, were disapplied, but everything else seems to have continued to apply as before. And we then, in chapter 4, trace legal history up to the 20th century and look at what happened. And the main issue we found is that nothing seems to have occurred that actually changed the nature of chancel repair liability. It arguably looks as if it remained an obligation on somebody who's got a religious office, albeit they're not necessarily a religious person. So this is tentative because the history is complex and there's some decisions in the late 19th century that seem to go a different way. But what did happen is that the property that had formed rectories became increasingly fragmented. Earlier on, a rectory was an estate in land. It was transferred as a whole, and it would take with it the church and the house and the glebe land and the tithes, all went by one transfer of a rectory. By the end of the 19th century, the land that had formed rectories has become very much split up, and the land is being sold without reference to the rectory. And additionally, various rights of rectors have disappeared. So any rights over common land have been replaced by the Enclosure Acts over 3 centuries with grants of land, and there's no more rights to tithes. Tithes are gone as of the Tithe Act 1836 to be replaced by tithe rent charges, and then tithe rent charges are eventually got rid of by the Tithe Act 1936. But having looked at these acts, none of them seem to make a difference to chancel repair liability. It looks as if it's still an aspect of a religious office. The 20th century, there's only 2 things I want to highlight here. There are 2 problematic cases. I will go back on. Yes, there we go. So there are 2 cases that caused some difficulties in the 20th century. They don't actually look at the nature of chancel repair liability or say that it is something different, but they do look at aspects of the liability. Wickenbrook, this is the decision about what happens when a rectory has been split up and you've got lots of lay rectors in a parish. And the Court of Appeal holds that chancel repair liability is a several liability, meaning that every lay rector is individually liable for the full costs of repairing the chancel. So if you have a rectory that's been split into 100 plots of land, and one owner of a cottage, which happens to be on that land, counts as a lay rector and is liable, you can get from that one owner the full costs of repairing the chancel. This point is frequently misunderstood because parochial church councils don't tend to do this. But Wickenbrook's fairly clear that you can, and that the poor owner of the cottage would then have to try and get a contribution from the others if they could. The other decision, which is much more important for our report and the issues we're looking at, is Shivers and Sons. And that's the decision. It's only a decision for the High Court. And we give some reasons in the consultation paper why it might have been wrongly decided. But that's the decision that holds that a person who buys any property that used to belong to a rectory automatically becomes a lay rector, whether they knew about it or not. And because they automatically become a lay rector, they automatically become bound by chancel repair liability. So Chivers is the decision that creates a problem for purchasers of land, because if you buy land and it happens to be land that traces back to a rectory from the 16th century, you're a lay rector and you're liable. Moving forward, why does this history create a problem for the Land Registration Act, and what are we proposing to do about it? Well, in chapter 5 of the consultation paper, we talk about how the Land Registration Act is making provision for registering interests affecting estates, the adverse right affecting title to an estate. And our concern is that chancel repair liability is not an adverse right affecting title and is not an interest in land. Our concern is that it's a personal obligation on a lay rector. It's an aspect of their religious office. It's just that they get the office because they've bought the land, but the liability isn't directly related to the land. It's one step removed from it. And if that's right, which is a big if, then there's a worry that the Land Registration Act may not properly deal with chancel repair liability. In other words, that you might buy a piece of land, there might be no notice of chancel repair liability registered against it. But because when you get the land, you automatically become a lay rector, you become bound by the liability as a personal obligation on you as lay rector, not as a burden on land that the Act would have dealt with. So to illustrate this, following Chivers, if it was rightly decided, if we've got person A, they own some land that belonged to a rectory, some rectoral land, and according to Chivers, which could be wrong, they then automatically possess the office of rector. And because they possess the office of rector, they're bound by chancel repair liability. So person A is going to sell the land to B. So B now owns rectoral land L. And following Chivers, because they own rectoral land L, they therefore possess the office of rector automatically. There's an automatic transfer of the office that happens with the land. So B is bound by the chancel repair liability. That's the worry that we've encountered in the report, in the consultation paper. And so we've provisionally proposed that the Land Registration Act should be amended to clarify its application to chancel repair liability. So in Appendix 3 to the paper, we've prepared a draft bill or a draft clause that would amend the definition of interest affecting an estate in the Land Registration Act. And what this says, well, I've put it up on the screen if you want to read it. But what it says is that if someone's liable to repair a church because they've got land that's rectoral land, it's not specific about how that's arisen. So it's meant to be general and catch all kinds of interpretations of the law. The liability for the purposes of this act is to be treated as if it's an adverse right affecting land. And because of that, Section 29, Section 32, other sections that we talk about in the consultation paper should automatically apply. And to make it absolutely clear, we then go on and say in subsection 5 that if, because of the provisions of the Act, chancel repair liability is postponed, so if Section 29 is applied, what that means is that you're not subject to the liability, to make it absolutely clear. But there is an issue. If we put that amendment, if we amended the Act in that way, in the ordinary manner, so that the Act from, say, 2026 has got this new provision in it, then that's going to apply to all sales of land that happen from 26 onwards. But what about sales of land that have happened between 2013 and 2026, when chancel repair liability stopped being an overriding interest? We could cause all sorts of doubts about the effects of these transfers if we just change the Act prospectively. So there is a proposal in the consultation paper for retrospective legislation. legislation that changes the law in the past. That's very unusual. There's a presumption that Parliament won't do that. But in this instance, we think it was widely believed the Act applied to chance repair liability, and that could be right. We've raised some concerns and some uncertainties. They're not necessarily correct. If this case might go to court, the Supreme Court might say, no, there's no problem here. But it was widely assumed that you had to register chance repair liabilities by 2013 or risk losing them. And it looks as if parochial church councils acted on that basis. There was a huge rush in registrations in the run-up to 2013. We think it's very unlikely that a parochial church council will have been saying, well, we could register our rights, but we think there's maybe an uncertainty in the law based on the very technical issues that the Law Commission have now looked at in chapters 2 to 5. So we've decided not to, and now we've been prejudiced by a retrospective amendment. We strongly suspect that there will be no case where that has happened, but we are keen to hear from consultees about whether there could be any prejudice in clearing up the law retrospectively, because that is the key question. Retrospective legislation is not objectionable if it causes no prejudice, but if it does, we may need to think again. So thank you. That's all I've got to say about the Act and the history of chance repair liability. Our headline is that we, having looked at the law, my personal view and the views of the Commission have changed. We think there is an uncertainty about whether the Land Registration Act properly applies to chance repair liability. We are not definite in our conclusion, but we think it's worth clarifying the law. And the aim would be to ensure that when you buy land, if there's no notice of chance repair liability, you know you're not going to be bound. And consequently, to reduce the need to take out insurance or to conduct searches. Now, if I stop showing my screen, there are a number of things I haven't spoken about. I haven't talked about first registration. I haven't talked a huge amount about the experiences of ordinary landowners either, or about some of the other unattractive aspects of chance repair liability. We're very happy to chat about anything that anybody wants to talk about. So why don't I open it up for questions? If you want to pop questions in the Q&A, you can, but you can also unmute. I will set up everyone's mics, so you're free to unmute. And if you don't have any questions for us, I'll have some questions for you. But at that point, if anybody has any questions that you want to ask orally, stick up a hand. Otherwise, you can post something in chat. Okay, well, then I will ask you some questions. Has anybody here either, if you're a legal professional, acted in relation to a sale of land where you've taken out chance repair liability insurance, or have you bought land where you've taken out chance repair liability insurance, or have you ever been involved in disputes connected to chancel repair liability, either for a parochial church council or that you've owned a piece of land and a local church has said you might owe them money. Thanks, Jamie. Jamie, can I ask what is your job? What role do you have? Has a client ever questioned the need for providing an indemnity insurance? And if they have, do you know what you've said? So, for example, when I bought my house, there was a chancel repair liability policy. It was only £15 in it. And I didn't immediately question it, but I did ask, if you took that out, would it make the insurance cheaper overall? Because it was also covering a number of other things. And the answer was no. So I sort of, fine, we'll take that. But have any clients raised questions with you?
Hi, Christopher. Sorry, I've been trying to encourage my husband to chat with you as well. So he's a residential property solicitor, and I'm a law lecturer. So I teach property law, and his experience is very much that they take out indemnity insurance in pretty much every case, and it's cheaper to do that than it is if you carry out the search first and then need to take out the insurance. So it is just routine to safeguard the client. And from the issue of trying to teach it, students just do not understand chancel repair liability. Is really difficult. It's so historic. And yeah, the first question is, what is a chancel? And I always struggle to explain that as well. So thank you for your explanation. That's really helpful.
The
Sorry, I was going to just jump in there as well. Sorry,
Sure.
it's Neil. I'm a partner in a conveyancing firm, a head of department, and we take out chancel insurance as a block policy. So all the properties that we deal with are covered by that policy. It's the cheapest way of dealing with it, and I wasn't necessarily sure I understood the risk before your presentation. I understand it a little bit more now, and it's just the cheapest way of dealing with any risk. I think we pay something like £7 or £8 per property on a block policy, and given the potential risk, it's just worth taking that insurance out. We'd never get questioned about it by a client.
Incidentally, does is the policy just a chancel repairs policy? So we've spoken to some of the providers who provide policies that just cover chancel repair liability insurance, but I'm aware that some insurance providers will give you a policy that will cover a number of matters, with one low price, say sort of £25, and it'll cover you for a number of things. The policies you use, are they individual to Chancel repair liability?
It in that particular case, yes, that we have a standard block policy where we just provide a schedule of all the properties that we've transacted on during the course of a month, and they are automatically included, and we just pay a premium based on a price per property.
So one thing that we have in mind is that if we wanted to change conveyancing practice, we would it would need to feed into conveyancing practice by anything we did would have to feed into conveyancing practice by a number of steps. So it might be, we were hoping that our amendment of the Act, if it goes ahead, might then be a basis for Land Registry to take the qualification out of their guidance, and possibly for any qualifications that currently appear in conveyancing handbook also to be changed. And then that may mean that it's less usual to take up block policies unless there's actually a notice on the register. Does that sound right? What is it? How would the law need to change for you to stop thinking it was worthwhile to take out a Chancel repair liability insurance policy, given that it's only £7?
Certainly, from my point of view, I think clarity from a statutory point of view, but also confirmation from a land registry point of view, or clarification from a land registry point of view, and then it's the industry acceptance of that position. Just because where there is any risk or doubt, or where the way that we deal with transactions is different to the way the rest of the profession is dealing with transactions. You don't want to be an outlier with what you are doing or how you are conducting transactions. So it's having that acceptance of a understood position across the profession.
Yeah. And one of the upshots of our consultation paper, at least as if our analysis is correct, is that it would be quite difficult to criticise a solicitor or conveyancer who says you might as well take out a policy, because the law is such a mess on Chancel repair liability. I've presented the main sort of themes and gists of it, but there are cases that say all kinds of things, and there are cases that are inconsistent with other cases. So while we are quite reasonably confident in our analysis, it is certainly not impossible that somebody might take a different interpretation of the historical bits of our paper. And then when we come to the Land Registration Act, I've said, well, it applies to interests in land principally. So if this isn't an interest in land, if it's a personal obligation on an office holder, it may not be caught. There's a good argument for that, but it may not be right. I certainly, it's worth thinking about what would happen if a case ever went to court, whether a judge would be likely to find that somebody bought land was bound by an unregistered Chancel repair liability, when that isn't the intention of the Land Registration Act, and if it's going to cause them prejudice. On the other hand, we did think that if somebody raised a somewhat different case, so they said, I've bought land and there is a registered Chancel repair liability, but I'm still not bound by it because Chivers was wrongly decided, and you don't automatically become a rector from buying rectoral property. It might be the courts would go a different way. But to cut a long story short, the law certainly seems uncertain.
Yeah, and I think for your average conveyancer who is probably doing a conveyancing transaction for maybe, if you're lucky, £1,000, maybe less than that, maybe a profit on the whole job is 100 quid or a couple of £100 at most. Conveyancers aren't looking to be able to advise clients in any way near the level of detail that you might need to advise about risk, when you can easily insure against that risk for £7 or £8. It's the reality is you're just going to take the insurance out.
There's a comment from Adrian about insurance and digging. Our understanding from conversations with insurers is that while policies are readily available and are cheap, they become increasingly more expensive and more unavailable the greater the risk that the land is actually subject to chancel repair liability. So having searched the records of ascertainment and found there is a historic liability in your land, you may not get the £7 or the £15 policy anymore. And once there's a registered liability on your land, you almost certainly won't. And I mean, where the liability has been enforced, it looks as if it would be almost impossible to get insurance. So I know that the wall banks, after they were found liable for the nearly £200,000, they couldn't sell their property initially. They had to sell the property to cover the debt, but they couldn't. So they had to compound the liability using the power under the ecclesiastical dilapidations measure. That is still available if you've got a liability and want to get rid of it. The problem is it's quite expensive. You've effectively got to pay enough to put the church in repair and insure it for the future, which can be quite a bit of money. I think it was about £35,000 for the wall banks, but they had just spent £200,000 rebuilding the church. So presumably it was in quite good shape by the time they spent the 35 to get rid of the liability.
And I was just having a look at our policy. We pay £7 per property with a value of the property up to £1 million, and then on our standard policy, it's £13 for properties between £1 million and £2 million. That just gives you an idea of where we sit looking at risk and cost. It's cheaper to take out the insurance than to do the search. So why would you do this?
Presumably that's non-search insurance.
That's yeah. We're not searching to see whether there is a potential liability. We're just going straight to insurance.
Presumably you need to tell the insurance if there is actually a notice of chancel repair liability on the.
Yeah, if there's anything registered, then we would need to notify on that basis, and it wouldn't be insured on the same terms. But I think in all my experience, and I've been doing the job 25-ish years, something like that, I think I've only ever come across one registered chancel liability. Maybe we're based in South Yorkshire. I'm not sure whether that has an impact as to where the greatest risks are, but it's not something that I've commonly come across.
Yeah, we had there is some data from Land Registry about how many applications they get to register notices for chancel repair liability. It looks like it was about 100 a year. There's a peak before 2013 when 1,000 or 2,000 are registered, and it's slightly dropped. Although interestingly, there are still 80 or so applications a year to register, but still that's not big across however many registered titles there are, many millions. Did anybody have anything else they wanted to share on practice or insurance or actual encounters with the liability? Then let me ask you quickly about retrospectivity. We think that in this case, clarifying the Act and doing it retrospectively, so it's backdated to when the Act came into force, won't cause anybody any prejudice, because insofar as one dealt with chancel repair liability at all, the 2013 date was pretty widely published. It was also the date when various manorial rights ceased to begin overriding interests, and it seems to have been pretty widely assumed that after this date, parochial church councils needed to register notices if they were going to protect their rights. Does anybody know of anything that would suggest otherwise? I know that we have Adrian from the Church of England who's here too, but good. Okay, that's fine. If something does occur to you, though, feel free to throw it in chat or just email the team. Our email address is on the invites. Right. I will maybe say something a little bit about unregistered land, which I didn't discuss at all in my presentation. Very briefly, unregistered land is subject to the rule in Chivers and Sons. So unless that case is wrongly decided, which again, it might be, we give some, I think, fairly strong reasons to think that it is in the report. But Chivers is a High Court decision. It's not binding on the High Court, but it's all these cases will start in the County Court, and there it is binding. So to challenge it, someone would have to appeal. If Chivers is right, chancel repair liability automatically transfers with ownership of land because you automatically become a lay rector if you buy any land that used to be part of a lay rectory. So that's a problem because the liability could be extensive and there's nothing that might tip you off. No one might know the land has a chancel repair liability. It's not subject to any limitation period. It can sit undiscovered for centuries. But if it's there, you look like you're automatically bound for unregistered land. We did consider whether we should reform the law for unregistered land and require chancel repair liability to be registered in some way. Because, I mean, there's the land charges scheme for land registration, for unregistered land, where you can register a land charge in the name of the owner. And the Land Charges Act provides that you're not going to be bound, well, for most classes of land charge, you won't be bound by it unless it's put in the land charges register. So we wondered if you could use something like that for chancel repair liability. We haven't proposed that, although we've asked a question about it. The reason is this, we're really looking at freeholds. There is a query about whether leaseholders might be subject to chancel repair liability, but they haven't been pursued for it for at least 200 years. So we're really looking at freeholds, and we're looking at people who acquire freeholds. And if you acquire an unregistered freehold, you're going to trigger a requirement of first registration. And part of our clarification of the Land Registration Act is to say, when you go through the process of first registration, if you don't record a chancel repair liability on the register, you're not bound by it once you've become registered as the owner. So we think that will deal with it. Briefly, our reasoning is this. If you know there's a chancel repair liability because it's in the title deeds, then you know about it and you're not an unwitting purchaser and you're not one of the people that in this project we are trying to protect. If you don't know about it, it'll be because it isn't in the deeds or there's no sign of it. And if it isn't in the deeds, then Land Registry aren't going to know about it either when you submit your application for first registration, unless the parochial church councils lodged a caution against first registration. And if they have, then the purchaser of land will know that because they'll check the register of cautions. But if they haven't, it's never going to come to the attention of the registrar, or it's highly unlikely that anyone's going to realise it exists and tell the registrar mid the process of first registration. So probably if a purchaser of unregistered land doesn't have a reasonable means of knowing that they're going to be bound by chancel repair liability, and then when the property is registered for the first time, the liability is going to drop away anyway, according to if our proposal were to be implemented. So we think that deals with unregistered land. Which is nice because it's simpler and we can do everything in one act. But I don't know if any of you deal with unregistered land. It's increasingly rare.
we still deal with unregistered land. You do still come across it from time to time. It's but the proposal sounds fine to me.
Obviously, working for the client that I do, I come across it an awful lot of the time. And what I'd say is it greatly depends on the quality of the application that's put in. Not necessarily in relation to chancel repair, but I have come across quite frequently where interests haven't been disclosed, for example, by lodging a Form DI, and there's been subsequent need to rectify the register to amend it. So I do have some personal reservations about the first registration application being conclusive, based on what somebody sends in with their FR1 and DL.
We're in slightly difficult territory for first registration, because of course this isn't a project on land registration, and we're not looking to clean up first registration full stop. But there is an uncertainty under the Land Registration Act about the effect of failing to record something during first registration and whether that's a mistake and whether it's rectifiable. Because while there's a lot of case law on rectification, to our knowledge,
rectification and omission, whether it's mistake or a rectification,
to our knowledge, the court hasn't yet considered that question. And unlike Section 29 on transfers of land, of registered land, where the Act is pretty clear about what it is you should register and what is and isn't binding, the scheme in the actual Act for first registration is threadbare. There's nothing in the Act that tells you about what you should and shouldn't record. It's all in the rules. And not only that, it's mostly in the prescribed forms, the form that says, please declare your FR1, please declare any interests you're aware of, box 10 or 11. Colin would know, but he's muted. So the law around first registration is a bit uncertain. In our 2018 report, we said that whether it was intended or not, the effect of Section 11 on first registration is that if an interest is not recorded in the register on first registration, it does cease to bind. Whether you can then rectify or not is another matter. But in the 2018 report, we did say that because of the way the Act's framed, that does mean that in the interim, you are not bound by the interest. It has dropped away. And we haven't yet found anything to suggest that view is wrong. On rectification, it would depend whether it's a mistake. And that's uncertain. We don't have a proposal to remedy that. However, if we're right, the interest does drop away, meaning that you do have to rectify the register, there would be an indemnity then paid to them, unless there'd been lack of proper care in the applicant not mentioning a notice, not mentioning adverse interest. It's possible that Land Registry would owe the first registered proprietor an indemnity for the chancel repair liability. Right. I think, well, we've nearly been going for an hour and a half. I will do a catch-all. So is there anything that anybody wants to tell us about either our project or chancel repair liability in general? Or if you've got any independent questions for the Law Commission, now is your chance. Well, I'll finish with a future look. The consultation period will close on the 15th of November. I'm pleased if you want to feel free to respond to it using the online form. This isn't a project where we're going to be inundated with responses. So if, for example, you were to send the Chancel Repair at Law Commission.gov.uk inbox a message saying, well, I'm not really responding to your consultation, but I want to tell you the following, we could take that into account. That's fine. We'll read through all the responses we get over Christmas. I don't know when we will do the report. It depends on competing priorities with other projects. But I don't think the report will be very long unless consultees raise new and difficult issues that we've missed in the consultation paper. Assuming that doesn't happen, it should be quite short and will come out in the fullness of time when we can get round to it. Apart from that, our property team's busy. Many of you may also be interested in other projects that are either ongoing or starting up. Our review of commercial leasehold is still ongoing and is now expanded to look at extra acts. We are commencing a project on housing estates, looking potentially to extend the right to manage to freeholders of houses, which might be of interest to those in the property industry. And sure thing, yeah. And we have a project in the early stages, not yet fully commenced, on ownerless land on Astute and Bonaventura, which is another tricky area of law, but much higher impact than Chancel Repair liability, because it arises surprisingly often in company insolvency and personal insolvency, dissolution of companies, intestacy. So watch this space. We probably will be putting stuff out on those various projects over the next year. Thank you, Adrian. And thank you very much for coming. It's much appreciated.